Welcome back to the Deep Dive. Today we are undertaking, well, a really deep dive into a truly foundational topic in conflict of laws. Jurisdiction.
Mm.
It's not just some dry procedural point. It's, the essential first question in any case that spills across borders. Who gets to decide? Which court has the power?
Exactly.
And honestly, in practice, you see cases turning on jurisdiction more than almost any other area in this subject.
Absolutely. Hello, everyone. Look, understanding jurisdiction is the gateway to conflict of laws. Before you even ask which law applies, you have to figure out if the court you're in can even hear the case at all.
And this in-depth exploration, this deep dive into the kind of nuts and bolts of jurisdiction, is made possible by materials generously provided by the University of London.
That's right.
We want to explicitly highlight that these documents are available for educational purposes, designed particularly to support students, in their learning journey.
Yeah, we're incredibly grateful for the access to these valuable resources. And this session is brought to you by Sinorbit Academy, Sri Lanka. We sincerely hope this deep dive clarifies the complexities and boosts your confidence. To all students preparing for exams, we want to wish you the very best of luck. You've put in the work. Now let's solidify this knowledge.
So let's talk about that power of the court jurisdiction.
Yeah.
Historically, in England, figuring out if the High Court had that power involved navigating between, well, two different frameworks.
That's really key to understanding the landscape. For many years, especially once the UK joined the European Economic Community and later the EU, you had the regime based on European regulations,
Right.
starting with the Brussels Convention and evolving into the Brussels Regulation recast. But running parallel to that, always existing, were the traditional older common law rules for establishing jurisdiction.
And this is where recent history dramatically changes the picture, as the source material points out.
Yeah.
With the UK's departure from the European Union, specifically through the Civil Jurisdiction and Judgments Amendment EU Exit Regulations 2019, the Brussels Regulation recast effectively stopped applying to civil and commercial cases started in the UK on or after the 1st of January 2021.
That date, 1st January 2021, it's crucial. While the EU regime provided a harmonized set of rules primarily based on the defendant's domicile within an EU member state.
Yeah, the domicile rule.
That is no longer the standard starting point for new cases in the UK for defendants outside the UK. Now, while there are some specific scenarios where the EU framework or related conventions might still pop up,
Well, sure.
like existing contracts with jurisdiction clauses referencing the old regime or specific international agreements, the primary framework for cases involving defendants not domiciled in an EU member state has reverted in large part to the traditional common law rules.
So if you're suing, say, a company in New York, an individual in Russia, or a business in Japan, you're typically looking at the traditional rule.
Pretty much, yes.
This means understanding this historical shift is vital, but our deep dive today, guided by this material, will focus squarely on those traditional rules, because that's what you'll primarily need to apply in many international scenarios now.
Exactly. To make sense of this, we'll first briefly touch on the historical journey that brought us here. Then we'll explore a fascinating, sometimes challenging area that limits a court's power even when jurisdiction might otherwise exist, the doctrine of immunities.
Ah, yes, immunities.
This is where conflict of laws rubs shoulders with public international law.
Interesting overlap.
And finally, we'll dedicate significant time to breaking down the core pillars of the traditional common law rules for establishing jurisdiction: presence, submission, and obtaining permission for service out of the jurisdiction.
Our mission is to pull out the most important concepts, the facts you need to grasp, and the key case names that illustrate these principles. We know you're likely preparing for exams, so we'll be repeating those crucial names and concepts to help them stick in your mind. By the end, you should feel much more confident navigating immunities and, critically, applying those traditional common law rules.
Let's get started on this journey then.
All right, let's unpack the history first. Taking us back before the significant changes brought about by European integration, specifically before, 1st January 1987, how did you establish the High Court's jurisdiction?
Back then, it was fundamentally based on service, getting the legal documents to the defendant.
Service, okay.
The court generally had jurisdiction if you could serve them. There were two main ways to do that. The most common was serving the defendant while they were physically present within England and Wales.
Just physically present, that seems quite broad.
It was very broad. The other way was serving the defendant outside England and Wales.
Right.
But this wasn't automatic. It required obtaining the court's specific permission for service out of the jurisdiction.
Ah, okay, permission needed.
Yeah. This distinction between service in based on presence and service out requiring permission is fundamental to the traditional system, and it's still relevant today.
So even if you could technically serve someone, did the court always have to hear the case? Was it automatic?
Not necessarily, no. And this is where the concept of discretion comes in, which is like a hallmark of the traditional rules.
Discretion.
Even if a defendant was served while present in England, the court began to more clearly assert a power to stay or halt those proceedings, particularly in the 1980s, if it felt England wasn't the appropriate place.
So stop the case.
Yeah. And for service out, the court had total discretion to refuse the permission needed to serve them abroad if it wasn't satisfied.
Okay, so service presence, permission for service out, and this element of discretion that was the pre-EU landscape.
That's pretty much it.
Then came Europe. The Brussels Convention was signed in 1968 by the original member states. How did the UK fit into that?
Right. The UK, along with Ireland and Denmark, joined the convention in 1978 through an accession convention. This brought the convention rules into UK law, though with some initial modifications. The convention was really designed to simplify jurisdiction rules between member states
Make things easier.
and ensure judgments from one member state could be easily recognized and enforced in another. It generally mandated jurisdiction based on the defendant's domicile within a member state. Domicile was key.
And it kept expanding, didn't it? Greece joined in 82, Spain and Portugal in 89, which brought even more changes with the San Sebastian Convention.
Yes, more change.
And then later EU expansions brought more countries under its umbrella.
Correct. And there was also a parallel framework, the Lugano Convention of 1988, which extended similar rules to relations between EU states and some EFTA countries like Iceland, Norway, Switzerland.
Lugano.
Right. So you had this growing European layer governing jurisdiction for defendants domiciled within that bloc.
And the European framework itself evolved from a convention to regulations, right, which are stronger.
Yes. The Brussels Convention was replaced by Council Regulation, EC 442/2001, known as the Brussels Regulation. That took effect from 1st March 2002 for most member states.
Okay.
Regulations have direct effect, making the rules more uniform across the EU. Then, Regulation 442/2001 was itself repealed and replaced by Regulation 1215/2012, the Brussels Regulation recast, which applied from 10 January 2015.
The recast version.
Yeah, the recast version. It aimed to improve upon the previous one.
So for almost 4 decades, UK jurisdiction rules for cases involving parties in the EU were largely dictated by this European framework. But then,
Right.
Brexit.
Precisely. And this is the critical turning point the document highlights. The Civil Jurisdiction and Judgments Amendment EU Exit Regulations 2019 ensured that from 1st January 2021,
The key date again?
the Brussels Regulation recast ceased to be directly applicable law in the UK for civil and commercial cases commenced on or after that date. This means that for new cases, the detailed domicile-based rules of the Brussels Regulation recast no longer govern whether UK courts have jurisdiction simply because the defendant is in an EU state.
So, the history shows this movement from a purely common law system based on service and discretion to incorporating and being largely superseded by a harmonized EU system for a significant category of cases.
Right.
And now, for defendants outside the EU, the focus shifts back to those original common law principles that were always there, just operating kind of in the background of the EU regime.
Exactly. That relationship is key. The traditional rules weren't abolished by the EU framework. They continue to apply to cases outside its scope. Now, post-Brexit, that scope has significantly expanded,
Right.
making a solid understanding of the traditional common law rules absolutely essential again, especially for cases involving defendants outside the EU bloc.
It really underscores why we're spending this time on them today. They are front and center once more.
Okay, now before we get into the specifics of how you establish jurisdiction under those traditional rules, we need to talk about something that can act as a complete barrier.
A roadblock.
Yeah, preventing the English court from hearing a case even if one of the grounds for jurisdiction technically exists. This is the doctrine of immunities.
Ah, immunities.
It's a fascinating area because it brings in principles of public international law directly into our domestic court process.
So who or what gets this special shield from being sued?
Well, the primary category is foreign states. The fundamental principle, subject to crucial exceptions, of course, is that a foreign state is immune from the jurisdiction of the English courts.
And this principle has deep roots. captured famously in a classic case.
Yes, in the Christina, back in 1938, let's repeat that case name. The Christina. Lord Atkin laid out the classic statement.
Okay, the Christina.
He said, and I'm quoting here, "The courts of a country will not implead a foreign sovereign, that is, they will not by their process make him against his will a party to legal proceedings, whether the proceedings involve process against his person or seek to recover from him specific property or damages."
Powerful stuff.
The core idea is really potent. You cannot, through the English court system, force a foreign state to become a party to litigation against its will. That's the principle from the Christina.
So originally a common law principle, how is it applied today? Is it still just common law?
Well, in England, this principle is now enshrined in statute, primarily the State Immunity Act 1978.
Ah, the 1978 Act.
Yes. Section 1 of that act confirms the general rule that a state is immune from the jurisdiction of the courts of the United Kingdom. Section 1, remember that.
Section 1.1, got it. Now, here's where it gets really interesting and frankly controversial. Doesn't this broad grant of immunity potentially clash with a fundamental human right?
Ah, you're thinking Article 6.
Exactly. The right to a fair trial and access to a court under Article 6 of the European Convention on Human Rights.
That is a critical tension, absolutely. And it was directly addressed by the European Court of Human Rights, the ECTHR, in the case of Al-Adsani v. UK.
Al-Adsani v. UK.
Okay, let's remember that case name. Al-Adsani v. UK. The ECTHR in Al-Adsani v. UK acknowledged that granting state immunity does constitute an interference with or a limitation upon the right of access to a court guaranteed by Article 6.1.
Okay, so it does engage the right. It is an interference.
Okay.
But the court must have found a justification for this interference.
Exactly. The ECTHR in Al-Adsani v. UK then considered if this limitation was permissible under Article 6.1. They held that the grant of sovereign immunity pursues a legitimate aim, complying with international law.
Complying with international law.
Okay, this compliance promotes comity and good relations between states by respecting their sovereignty. Furthermore, the court found the restriction to be proportionate because, at the time, state immunity for such acts was considered to reflect a generally accepted rule of international law.
Proportionality is key there.
Yeah, very much so. So, despite engaging Article 6, the limitation was deemed justified in Al-Adsani v. UK.
But this isn't settled law in the face of extreme circumstances, is it? The source flags up a particularly challenging case. Jones v. Minister of Interior of Kingdom of Saudi Arabia.
Ah, yes, Jones.
Let's repeat that name. Jones v. Minister of Interior Kingdom of Saudi Arabia. Here, British nationals sued the Saudi state and its officials in England, alleging torture they had suffered. Pretty horrific allegations.
Jones v. Minister of Interior of Kingdom of Saudi Arabia brought the tension right to a head. The claimants argued that because torture is prohibited by a peremptory norm of international law.
A peremptory norm.
Like a fundamental rule.
Exactly, a rule so fundamental and universally accepted that no state can ignore it. Just cogens is the term sometimes used. They contended that state immunity shouldn't apply to torture. Granting immunity for acts of torture was disproportionate, they argued, and violated their Article 6.1 right.
So how did the House of Lords handle this in Jones? Did the peremptory norm against torture override the immunity? Well, the House of Lords in Jones was clear. They held that both the state and the officials were entitled to immunity under the State Immunity Act 1978.
They still got immunity, even for torture.
Yes. They specifically found themselves unable to accept the argument that alleged acts of torture could not, for the purposes of the act, be considered governmental or official acts entitled to immunity. The court concluded that granting immunity under the 1978 Act in this context was not disproportionate and did not violate Article 6.1, even when faced with allegations of torture.
Wow.
Because the act reflected the current state of international law on state immunity for such acts, which, they found, hadn't carved out a general torture exception at that point.
That feels like a stark outcome, especially given the nature of the allegations. The document prompts us to think about cases like Jones and whether the 1978 Act should be reconsidered. It raises a fundamental question, doesn't it?
It really does.
Where do you draw the line between respecting state sovereignty to maintain international order and providing a remedy for individuals who have suffered horrific human rights abuses? The 1978 Act might not have fully contemplated such scenarios when it was drafted.
It certainly poses a dilemma that continues to be debated on the international stage and within national legal systems. And for the practical application of the Act, it's also important to know who or what qualifies as the state for immunity purposes.
Right. Who is the state?
The source confirms this includes the head of state, The sovereign, the government of the state, and any department of that government.
Okay, so that's the broad principle of state immunity and the difficult cases like Al-Thani and Jones that test its boundaries. But the State Immunity Act 1978 also contains specific, crucial limits to this immunity. The state isn't immune in every situation.
That's right. The general rule is powerful, but the exceptions are equally important. The Act specifies three key limits we really need to know. The first is submission.
Submission, okay.
Under Section 2.1 of the Act, that's S.21, a state can choose to waive its immunity and submit to the jurisdiction of the English courts. This can happen expressly or sometimes by implication through conduct in the proceedings.
So if a state voluntarily participates in the lawsuit, they might lose immunity. They waive it.
Yes, exactly. They've chosen to engage with the process. That's submission, S.21.
Got it. What's next?
The second key limit is the commercial transaction exception, found in Section 3.1. This one is highly significant, S.31.
Commercial transaction, S.31.
A state is not immune from proceedings relating to a commercial transaction it entered into. This is the difference between acting as a sovereign ruler, jure imperii, and acting more like a private entity in the marketplace, jure gestionis.
So if a state is buying or selling goods or borrowing money, those kinds of activities.
Precisely. If the proceedings relate to such a transaction, immunity is typically lost. Section 3.1 also removes immunity for proceedings relating to an obligation of the state, which, by virtue of a contract, falls to be performed wholly or partly in the UK.
Performance in the UK.
Yes. So if a commercial contract or a contractual obligation needs to be performed here in England, that also triggers the loss of immunity under this section. Remember, commercial transaction and obligation to be performed wholly or partly in the UK under S.31. Very important exception.
Okay, submission, commercial transaction. What's the third major limit?
The third is the contracts of employment exception in Section 4.1.
Employing contracts, S.4.
A state is generally not immune from proceedings relating to a contract of employment with an individual where the contract was made in the UK or where the work is to be wholly or partly performed in the UK.
Okay.
This is designed to allow local staff or staff working locally for an embassy or state entity to sue in English courts regarding their employment, although there are some complexities and limitations related to diplomatic staff and their official duties. But the basic principle is there in S.41. Remember the employment contract exception under S.41.
The source also mentions other categories of individuals or bodies that have immunity beyond foreign states themselves.
Yes. English courts also lack jurisdiction over persons entitled to diplomatic immunity, governed by statutes like the Diplomatic Privileges Act 1964.
Right, diplomats.
And the Consular Relations Act 1968. This is why an accredited ambassador or their core staff usually cannot be sued in English courts. Certain international organizations and their officials can also be granted immunity by specific UK statutes. Remember the Diplomatic Privileges Act 1964 and Consular Relations Act 1968 for diplomatic immunity.
Let's test our understanding with some scenarios from the self-assessment questions in the document. Make it concrete.
Good idea.
Scenario. An English company, A, has a concession from Government X to work mines in X. Government S repudiates the contract, and A sues for damages in England. Jurisdiction immune or not.
Repudiating a concession to exploit a state's natural resources within its own territory. That typically sounds like a sovereign act, doesn't it?
Feels governmental.
Yeah, an exercise of governmental control over its wealth and land. Unless there's evidence of State X submitting to jurisdiction under S.21, this kind of dispute is highly likely to be protected by state immunity. It's generally not considered a commercial transaction under S.3Q1 in the sense the act carves out, even if it involves commercial activity on the ground. The underlying act of granting or taking away the concession is governmental, so likely no jurisdiction due to immunity.
Okay, makes sense. Scenario 2. B, an English company, agrees to supply arms to Government Y. The contract is governed by English law. Government Y refuses to pay, and B sues in England. Jurisdiction.
Now, this feels different. Agreeing to supply goods like arms and a failure to pay for them.
Sounds like business.
Exactly. Sounds very much like trading, like stepping into the marketplace. This is likely covered by the commercial transaction exception under S.31. If the contract is a commercial transaction or has an obligation to be performed wholly or partly in the UK, like payment in London perhaps, the state will not be immune. So yes, the English court would likely have jurisdiction here, applying S.3. Remember, commercial transaction exception S.31.
Okay, that seems clear. Scenario 3. C, a British citizen is employed by Government Z to run its tourist office in London. He's dismissed and sues for damages. Jurisdiction.
This looks like it fits neatly into the employment contract exception under S.41.
Section 4.1.
Yes, it's an employment contract with an individual, and the work is performed entirely within the UK. Therefore, State Z is not immune from C's lawsuit. The English court would have jurisdiction. Remember, employment contract exception, S.4.
All right. Scenario 4. D is injured in a car accident caused by H, the chauffeur of a foreign ambassador. H is mission staff, his country's citizen, driving the ambassador's car. Liability for H, the ambassador, the insurer. Official business versus personal. This references Dickinson v. Del Solar.
Right. This involves diplomatic immunity under the Diplomatic Privileges Act 1964. H, as mission staff, would likely be immune from suit in English courts regarding the accident.
So D can't sue the chauffeur.
Probably not directly in England, regardless of whether he was on official business or not, though official duty might affect vicarious liability questions. The ambassador also has immunity.
So the driver and the ambassador are protected.
Yes. So D likely can't sue H or the ambassador directly in England. However, the critical point illustrated by Dickinson v. Del Solar, remember that case, Dickinson v. Del Solar, is that H's diplomatic immunity does not extend to the motor insurance company.
The insurers.
Exactly. So, while the chauffeur is immune, the injured party can usually sue the insurance company directly. Remember, Dickinson v. Del Solar for the insurer's liability, despite diplomatic immunity.
Okay, interesting wrinkle. Finally, scenario V. E. A British citizen is arrested and tortured in prison in state X. Can he sue the state of X or 2, the torturer in England?
This scenario brings us right back to the Jones case we discussed.
The torture case, Jones.
Yes. As held by the House of Lords in Jones, suing the state in England for torture occurring abroad is barred by state immunity under the 1978 Act. The court did not find a relevant exception or that immunity was displaced by the peremptory norm against torture in this context.
So, no suing the state. What about the individual torturer?
Suing the individual torturer in England is also very difficult. Jones suggested officials involved in such acts, even torture, might also be entitled to immunity as state representatives acting in an official capacity. So based on the current interpretation of the 1978 Act following Jones, actions against both the state and the torturer in England would likely be dismissed due to immunity. Remember the Jones case and its implications for torture allegations.
So, to recap immunities quickly, the core principle from the Christina, now in the State Immunity Act 1978, Section 1.1, is that states are immune.
General rule, yes.
This principle has been challenged under human rights law, Al-Atsani v. UK, Jones v. Minister of Interior of Kingdom of Saudi Arabia, but upheld by English courts as reflecting international law.
For now, yes.
However, there are crucial statutory limits: submission, commercial transactions, and contracts of employment.
Those 3 key ones.
Plus, other immunities cover diplomats. Dickinson v. Del Solar, Diplomatic Privileges Act 1964, and international organizations.
Understanding these immunities is vital because they are threshold questions. If immunity applies, the court has no jurisdiction, regardless of whether other rules for establishing jurisdiction might otherwise be met. It's the first hurdle sometimes.
It adds a layer of complexity, but it makes sense that international relations and sovereignty would put some limits on national court power.
Right. Shifting gears now to the core rules for establishing jurisdiction when a foreign state isn't involved and the defendant isn't domiciled in the EU. This is where the traditional common law rules come into play again with full force.
Back to the traditional rules.
We're focusing on jurisdiction in personam, the court's power over the person or entity being sued. Remember, traditional rules, common law, defendant not EU domiciled, and jurisdiction in personam.
And the source material highlights that these rules are less rigid than the now largely inapplicable EU regime, particularly because they involve the court's power to stay proceedings even if jurisdiction is established.
Absolutely. Flexibility and discretion are key features here. Now, the first and historically the most fundamental basis for establishing traditional common law jurisdiction is simply presence within the jurisdiction.
Presence. Just being physically present in England and Wales sounds simple.
Yes. The rule is that the English court has jurisdiction if the defendant is personally served with the claim form while they are physically present within England and Wales. Remember that core concept. Presence.
Does presence mean you have to live here or be here for a while? Or just passing through?
No, and this is where it can seem quite striking, perhaps even excessive, as the source mentions later. The presence can be incredibly fleeting.
Fleeting.
Yes. It does not require residence or domicile. Remember, Present. England and Wales.
Well,
Fleeting, not residence.
the cases really bring this to life. The source gives us Maharani of Baroda v. Wildenstein.
Ah, the classic.
I mean, the defendant was literally just visiting for the Ascot races. The lawsuit itself had no connection to England, but service at the racecourse was enough.
That's amazing.
A perfect, classic illustration of the reach of the presence rule. Another is Colt Industries Inc. v. Sarli, where the defendant was served during a brief few-day visit unconnected to the potential litigation.
These cases, Maharani of Baroda v. Wildenstein and Colt Industries Inc. v. Sarli, show just how broad the net of presence jurisdiction can be. Remember those two.
Are there any significant exceptions to this? Can you always serve someone just because they popped over for a day?
Well, the main exception is if the defendant was induced or tricked into coming into the jurisdiction by fraud or other improper means, specifically so they could be served.
Ah, okay, no tricking them in.
Right. Assuming service is proper, fleeting presence is usually enough. This principle was reaffirmed more recently in the case of Chelaram v. Chelaram, number 2, in 2002. Remember Chelaram v. Chelaram, number 2, for the reaffirmation?
How does this apply when the defendant isn't an individual but a business, a company, say?
Well, for partnerships, you can achieve service and thus establish jurisdiction based on presence by serving any one of the partners who is present in England.
Just one partner.
Yes, or by serving at the partnership's principal place of business in the jurisdiction.
And for companies?
For companies, it depends on their registration. If the company is registered right here in England, service is straightforward. You send or leave the claim form at its registered office. This is governed by Section 11139 of the Companies Act 2006.
Okay, Companies Act 2006, Shatmun 1139 for English registered companies. Got it.
Remember, Companies Act 2006, Chet.11391. 11391.
What about companies incorporated elsewhere overseas? Foreign companies?
These are referred to as overseas companies, defined in Section 1044 of the Companies Act 2006, Section 10044.
Overseas companies, S.1044.
The rules for service are in Part 34 of the Act. If the overseas company has registered a person in the UK authorized to accept service, you serve that person at their registered address.
Right.
If there's no such person or service is refused there, you can serve at any place of business the company has in the UK. There's also the possibility of personal service on a senior person, like a director, though the source notes some uncertainty about its universal application to foreign companies. Remember, overseas companies, Companies Act 2006, Part 34, S.1044.
So, going back to the idea of presence being excessive, why that label? What's the problem?
The label excessive comes from exactly those cases like Maharani of Baroda v. Wildenstein. Jurisdiction can be founded based solely on the defendant happening to be in England for reasons totally unrelated to the dispute.
Like going to the races.
Exactly. There's no requirement for the cause of action to have arisen here or for the parties to be resident or domiciled here. It's based purely on the power to effect service within the territory, the physical power.
Are there justifications for such a broad rule? Seems a bit rough.
Well, arguments for it include its historical basis. It's the oldest way courts asserted power over individuals. It also offers certainty and simplicity. If you can find and serve the defendant here, you generally have jurisdiction.
Fair enough.
However, as noted, this simplicity can lead to jurisdiction in cases with minimal genuine connection to England.
Let's apply this to sample exam question 1. A tennis player from California owes money to an English company. Next week, he'll be in England to play at Wimbledon. Can the company serve a claim form on him while he's here?
Absolutely, yes. Based on the presence rule.
The fleeting presence rule.
Exactly. His physical presence in England while playing at Wimbledon is sufficient to allow him to be served. It doesn't matter that the debt arose elsewhere or that he's only here temporarily for the tournament. It's a classic Maharani of Baroda scenario. Remember the tennis player example and the presence rule. Okay. The second basis for traditional common law jurisdiction is submission to the jurisdiction.
Submission, yep.
The English High Court has jurisdiction over a person or entity if they voluntarily submit to its authority, even if they couldn't otherwise be served here. They essentially agree to it.
How does someone submit? What counts? Is it just saying, okay, I submit?
Well, not usually that explicit. The most common ways are by taking a step in the proceedings that is only consistent with accepting the court's jurisdiction. This includes acknowledging service of the claim form without simultaneously protesting the court's jurisdiction.
Ah, so just acknowledging service can be submission.
It can be, yes, unless you protest. It also includes instructing a solicitor to accept service on your behalf.
Okay.
Another way is if you initiate proceedings as a claimant in English court, you are then deemed to have submitted to the court's jurisdiction for any counterclaim brought against you by the defendant in those same proceedings.
Makes sense, if you start it.
You have to accept the consequences. And crucially, parties can agree in a contract that the English courts will have jurisdiction over any disputes arising from that contract. That's known as a jurisdiction clause, and it constitutes submission.
Right, the jurisdiction clause in a contract. That's
Very
cool.
common.
This sounds a bit like a trap, though. What if you don't want to submit but need to respond to court documents? What actions should you avoid or specifically take not to accidentally submit?
That's a very important point, especially if you intend to challenge the court's jurisdiction. The key is to make it crystal clear that you are not accepting the court's power over you.
How do you do that?
Simply acknowledging service is submission, unless you explicitly state that you are acknowledging service only for the purpose of protesting the court's jurisdiction.
Okay, you have to say, I'm only doing this to protest.
Exactly. This principle comes from the case of Riedl's settlement, number 2. Remember, acknowledge service to protest jurisdiction, citing Riedl's settlement number 2 is not submission. Crucial case, Riedl's settlement number.
Okay, Riedl's is number 2. So you can participate just to object. What else is not submission?
Applying to the court for a stay of the proceedings is also not considered submission.
A stay. Because you're saying this isn't the right place.
Precisely. A stay application argues that the English court is not the proper or convenient place to hear the case, which is perfectly consistent with challenging its jurisdiction. This is established in the case of Williams and Glenn's Bank v. Astrodynamico.
Okay, Williams and Glenn's Bank v. Astrodynamico.
Remember, applying for a stay is not submission, citing Williams and Glenn's Bank v. Astrodynamico.
There's a subtle but vital distinction the source makes about contractual terms, choice of law, versus choice of jurisdiction. Can you clarify that?
Yes, this catches people out all the time. Just because a contract states it is to be governed by English law does not automatically mean the parties have submitted to the jurisdiction of the English courts.
Okay, different things.
Totally different. A clause choosing English law is about which law applies to the contract, not which court hears the case. You need a specific clause granting jurisdiction to the English courts for that. The case Dunby Ltd v. Gilman & Co., Australia, Peely Ltd., illustrates this distinction.
Dunby Ltd v. Gilman & Co.
Remember the difference. Choice of law versus submission to jurisdiction, citing Dunby Ltd v. Gilman & Co.
Can parties submit to English jurisdiction over absolutely anything? Are there limits?
Not quite. Parties cannot confer jurisdiction by submission if the matter is fundamentally outside the court's power under English law. For example, English courts generally lack the inherent power to determine title to foreign land.
Right.
And parties couldn't give them that power just by agreeing to submit. There are inherent limits.
Let's look at self-assessment Q3. You have a client, a Malaysian company, that's been served with a claim form in England, but they want to contest jurisdiction and avoid submitting. How would you advise them? What's the strategy?
Okay, Malaysian company served in England. They want to fight jurisdiction. Based on the rules, the key advice is about how they respond to the claim form.
What do they do?
They must acknowledge service, but when doing so, they must explicitly state that they are doing so solely for the purpose of protesting the court's jurisdiction.
Gotta use those magic words.
Absolutely. This is essential to prevent accidental submission, and you'd reference the principle from Riedl's settlement, number 2.
Riedl's.
Furthermore, they can apply to the court for an order challenging jurisdiction or seeking a stay of the proceedings on the grounds that England is not the proper forum.
The Williams and Glenn's point.
Exactly. Crucially, making such an application for a stay or to challenge jurisdiction is not submission, as confirmed in Williams and Glenn's Bank v. Astrodynamico. These steps allow them to engage with the court process to fight jurisdiction without being deemed to have accepted it. Remember the Malaysian company example, protest jurisdiction, Riedl's and Williams and Glenn's. So we have presence and submission as grounds for traditional jurisdiction. But as we noted earlier, presence can give jurisdiction where there's minimal connection, Maharani of Baroda again.
Right, the Ascot races problem.
Yet fail where there's a strong connection, but the defendant is abroad. Like, say, a contract made and broken in England, but the defendant lives overseas and never visits.
So you can't serve them here.
Right. This is why the third basis is so important. Service out of the jurisdiction.
This is when you need to serve the defendant outside England. But the case still feels like it should be heard here. There's a real connection.
Exactly. This has been possible since 1852, but always with permission of the court. You need the court's okay.
Permission again.
Yes. It's currently governed by the Civil Procedure Rules, CPR. Specifically, CPR 6.30 outlines that the claimant may serve a claim form out of the jurisdiction with the permission of the court. Remember, service out of the jurisdiction with permission, CPR 6.30.
And you highlighted that this is different from presence or submission because it's discretionary. The court doesn't have to grant permission.
Precisely. Obtaining permission is not automatic. This jurisdiction is discretionary. The court will not grant permission unless it is satisfied, among other things, that England and Wales is the proper place in which to bring the claim.
The proper place.
That test, the proper place, is found in CPR 6.373, remember, discretionary, proper place, and CPR 6.373.
What does the claimant have to prove to convince the court to grant permission for serve and allow? What's the burden?
Okay, the claimant carries the burden of proof and must satisfy 3 key requirements. These are absolutely critical to remember for exams.
3 requirements, okay.
First, they must show there is a serious issue to be tried on the merits of the claim. The claim can't be frivolous or, clearly hopeless.
Makes sense. A real case.
Second, they must demonstrate that the claim falls within one of the specific grounds listed in CPR 6.2. There are 19 of these gateways.
CPR 6.2 grounds.
The gateways. These grounds represent categories of cases deemed potentially suitable for English jurisdiction even if the defendant is abroad, based on some connection to England.
The third requirement.
Third, and often the most heavily contested point, the claimant must persuade the court that England and Wales is the forum convenient.
Forum convenience. The convenient forum.
Yes, meaning the most appropriate or suitable forum to hear the case in the interests of justice for all parties. The leading case on the forum convenience test under the traditional rules is Spiliata Maritime Corps v. Cancelex Ltd. Huge case.
Spiliata. Got it.
Remember those 3 hurdles? Serious issue, CPR 6.20 grounds, forum convenience, and the case Spiliata Maritime Corps v. Cancelex Ltd. You have to satisfy all 3.
So, meet one of the listed grounds and show England is the best place for the trial and have a serious case.
Essentially, yes. The Spiliata test for forum convenience involves identifying the natural forum by looking at factors like where the parties reside or carry on business, where the witnesses or evidence are located, the governing law of the dispute, and the enforceability of a judgment. A whole balancing act.
Okay.
For tort cases, the source notes it's often easier to show England as the natural forum if the tort was committed within the jurisdiction, as illustrated by the Albeforth. Remember the Albeforth for torts and the natural forum?
The source lists 19 grounds in CPR 6.20, but highlights some as particularly important. Let's go through those key grounds, the main gateways.
Good idea. For claims relating to contract, important grounds include if the contract was made within the jurisdiction,
Made in England.
if it was made by or through an agent trading or residing within the jurisdiction,
Agent here.
if the contract is governed by English law,
English law chosen.
if it contains a term conferring jurisdiction on the English courts, a jurisdiction clause,
Jurisdiction clause again.
or if a breach of contract was committed within the jurisdiction.
Breach happened here.
Yes, these are the key connecting factors for contract disputes under CPR 6.20.
And for tort claims, what are the grounds?
For torts, the ground under CPR 6.20 is met if the claim is founded on a tort where either the damage was sustained within the jurisdiction or damage resulted from an act committed within the jurisdiction.
So damage here or act here.
Exactly. Remember, damage sustained within the jurisdiction or act committed within the jurisdiction.
What constitutes damage for this ground? The source references a definition. Can't be just anything, right?
No. The definition comes from Metal and Rostoff, AGV, Donaldson, Lufkin, and Jenrette. It requires either that significant damage was sustained in England or that the damage resulted from substantial and efficacious acts by the defendant that took place in England.
Significant damage or substantial and efficacious acts. Okay.
It's not just any remote consequence here. Remember Metal and Rostoff, AGV, Donaldson, Lufkin, and Jenrette for the definition of damage?
The case of Berezovsky v. Michaels is mentioned in the context of the tort ground. What was that about?
Yes. Berezovsky v. Michaels was significant because it involved libel claims based on publications, including online ones, disseminated from abroad but causing damage to the claimant's reputation in England.
Libel tourism.
Well, it contributed to that discussion. This case helped clarify how the damage sustained within the jurisdiction ground could apply to such torts, particularly defamation, even if the defendant was located overseas. Remember Berezovsky v. Michaels for the tort ground and damage to reputation in England?
Moving on, Claims relating to property, what are the grounds there?
For claims involving property, grounds exist where the whole subject matter of the proceedings is land within the jurisdiction,
Land in England.
such as an action seeking possession of land. The source references Agnew v. Usher as an example.
Agnew v. Usher.
Another ground is for claims seeking to construe, rectify, set aside, or enforce an act, deed, contract, or liability affecting land within the jurisdiction, like suing a tenant for breaching a covenant in a lease. Tassel v. Hallen is the example here.
Tassel v. Hallen. Lease covenant. Okay.
Or claims concerning a debt secured on immovable property here, like a mortgage. Remember Agnew v. Usher and Tassel v. Hallen as examples for property claims?
What about restitution?
For restitutionary claims, there is a ground if the defendant's alleged liability arises out of acts committed within the jurisdiction. Acts here.
Okay.
The source notes this can include seeking equitable relief for breach of confidence, citing the case of Douglas v. Hello, Ltd. Remember the Douglas v. Hello Ltd. case for restitutionary claims like breach of confidence.
Right, the celebrity photos case. Finally, there's a ground relating to multiple defendants. How does that work?
Yes. If you are properly suing one defendant, let's call them D1, either served here or served out with permission.
We've already got jurisdiction over D1.
Right. You can potentially get permission to serve another person outside the jurisdiction, D2, if that person is a necessary or proper party to the action against D1.
Necessary or proper party.
Remember, necessary or proper party, the idea is efficiency, bring all relevant parties into one lawsuit. However, the court is cautious.
Why cautious?
They won't usually grant permission on this ground if the proposed second defendant, D2, has a strong defense, or if the claim could realistically proceed just against the first defendant, D1. There's also some reluctance to use this ground to pull in foreign parties who have no other real connection to England. It shouldn't be used just to drag someone in unfairly.
Okay, that makes sense. Let's use the remaining scenarios to apply these service out rules. Self-assessment Q4. You're suing a Russian defendant for damages for breach of contract. When will an English court give permission to serve the claim form on the defendant in Russia?
Okay, Russian defendant means traditional rules apply, and serving outside requires permission for service out of the jurisdiction.
Permission.
To get that permission, the claimant needs to satisfy the 3 requirements we discussed. First, a serious issue to be tried. Second, show the claim falls under a relevant CPR 6.2 ground for contract.
One of the contract gateways.
Yes. For a breach of contract claim, you'd look for connecting factors like, was the contract made in England? Is it governed by English law? Was the breach committed in England? The specific facts will determine if one of these grounds is met.
Check the facts against the grounds.
And third, and critically, you must persuade the court that England is the forum conveniens, the most suitable place to hear the case, applying the multi-factor test from Spiliata Maritime Corps v. Cancelex Ltd.
The Spiliata test again.
Yes. So permission will be granted if you can show a serious issue, meet a CPR 6.2 over contract ground based on the facts, and prove England is the forum conveniens. Remember the requirements. Serious issue, CPR 6.20 ground contract, forum conveniens, Spiliata.
Self-assessment Q5. A power station accident in Bulgaria causes damage to crops on an English farm. The farmer wants to sue the Bulgarian power station in England. Can he do this?
Okay, this is a tort claim, and the defendant is abroad in Bulgaria, so he needs permission for service out.
Permission needed again.
Again, apply the 3 requirements. Serious issue. Likely, if the damage is substantial. CPR 6.20 round. Yes, he can potentially rely on the tort ground because damage was sustained within the jurisdiction. The damaged crops are right here in England.
The damage happened here.
Exactly. Remember, damage sustained within the jurisdiction. Finally, he needs to show England is the forum conveniens, applying the Spiliata test. The fact that the damage occurred here strongly supports the argument that England is the natural forum.
Makes sense.
Maybe referencing the idea from the Albaforth. So yes, he can potentially sue in England, provided he gets permission by satisfying the serious issue, the tort ground, damage here, and forum conveniens.
Last one, sample exam question 2. Let's revisit that tennis player from California.
Okay.
This time, he didn't come to Wimbledon. He stayed in California. The contract was made in California, and it doesn't say English law applies. Can the English company get permission to serve him out in California?
Right. Serving him in California requires permission for service out. The claimant needs to show a serious issue, a CPR 6.20 ground, and forum conveniens. Let's look at the CPR 6.20 contract grounds based on the facts given.
What connects it to England?
Exactly. Was the contract made in England? No California. Governed by English law? No express choice. And made in California suggests foreign law might apply. Was a breach committed in England? Not based on these facts. Failure to pay might occur wherever payment was due, not necessarily England.
Seems weak.
Based only on the information provided, it seems difficult to find a relevant CPR 6.20 ground that provides a sufficient connection to England for a contract claim, without meeting one of those specific gateways in CPR 6.20 that links the dispute to England.
Like place of making, governing law, place of breach.
Permission for service out is unlikely to be granted, regardless of forum convenience. You have to get through the gateway first. Remember, service out permission, CPR 6.20 ground, and connecting factors.
That really clarifies that service out isn't just about showing England could be a good place to sue. You have to first find a specific reason, a hook, listed in the rules that connects the claim to England. The gateway.
Exactly. It's a multi-stage test culminating in the court's discretion. You need the gateway and forum convenience and a serious issue. ## summary review.
Wow, we've covered a lot of ground in this deep dive into jurisdiction under the traditional rules. We set the historical stage, seeing this shift from a purely common law system through the significant period of EU dominance for certain cases, and now the return to prominence for the traditional rules, especially for non-EU defendants post-Brexit.
And we explored the critical doctrine of immunities, understanding the general principle of state immunity from the Christina, codified in the State Immunity Act 1978, and how it's been tested in challenging cases like Al-Adsani v. UK and Jones v. Minister of Interior of Kingdom of Saudi Arabia.
Al-Adsani, Joe.
While also detailing the crucial limits under the Act: submission, commercial transactions, and contracts of employment, sections 213141.
Plus other immunities like diplomatic ones, Dickinson v. Del Solar.
Then we really dug into the 3 pillars of traditional common law jurisdiction in personam. Presence within the jurisdiction, remembering how fleeting it can be, Maharani of Baroda v. Wildenstein, Colt Industries Inc. v. Sarli.
Fleeting presence.
And how it applies to companies, Chalaram v. Chalaram. Number 2, Companies Act 2006.1139, Part 34, Chalar 11044. Submission to the jurisdiction, identifying what constitutes submission and, crucially, how to avoid it while protesting jurisdiction. Ray Dulles Settlement Number 2, Williams and Glenn's Bank v. Astrodynamico.
Ray Dulles, Williams and Glenn's. Don't submit by accident.
And distinguishing it from choice of law, Dunby Ltd v. Gilman & Co. And obtaining commission for service out of the jurisdiction, which is discretionary, CPR 6.3, CPR 6.373, requires meeting 3 key requirements: serious issue, CPR 6.2 air ground, and forum convenience from Spiliata Maritime Corps v. Cancelex Ltd. Spiliata, absolutely central. We also detailed some of the most important CPR 6.20 grounds, including contract, tort, remembering the definition of damage from Metal and Rostoff, AGV, Donaldson, Lufkin, and Jenrette, and cases like Berezovsky v. Michaels, property, Agnew v. Usher, Tassel v. Hallen, restitution, Douglas v. Hello Ltd., and multiple defendants. By explaining these concepts, rules, statutes, and cases, and applying them through scenarios, we've covered the core areas related to immunities and traditional jurisdiction rules as outlined in the source material.
We've aimed to repeat those key terms and case names like the Christina, Jones, Spiliata, Maharani of Baroda, Erdolis, Williams and Glenn's Bank, and specific section numbers and CPR rules to help you embed them for your studies and, of course, your exams.
You should now have a solid framework for understanding when an English court has or is prevented from having jurisdiction over parties in international disputes under the traditional common law system, hopefully feeling a bit clear.
Feeling a little more prepared to tackle those questions now.
We certainly hope so. That's the aim. #tag outro.
That brings us to the end of this deep dive into jurisdiction under the traditional rules and the doctrine of immunities. It's a complex but absolutely vital area of conflict of laws.
It really is foundational. We want to extend our sincere thanks once again to the University of London for providing the valuable educational materials that made this exploration possible for students.
Absolutely. And this deep dive was brought to you by Sinorbit Academy, Sri Lanka.
Wishing all of you the absolute best of luck with your upcoming exams. Go in there feeling confident. You can do this.
As a final thought from this material, maybe consider the continuous tension we observe throughout this discussion. The historical assertion of jurisdiction based on mere presence, however brief, Maharani of Baroda, contrasting with the principle of state immunity designed to protect sovereignty and international relations, even in challenging circumstances like those seen in Jones.
That tension is palpable.
It forces us to ponder. In a globalized world, what is the fundamental basis for a court's power over a foreign party? And how should that power be balanced against the equally valid needs for access to justice and international comity? Where should the line be drawn?
A question worth reflecting on long after the exam.
Indeed. Until our next deep dive.
Goodbye, everyone. Good luck.